Good evening, everyone. So we are starting this session right now. We have with us Josh, founder of Perkchop, serial entrepreneur and technologist, and with us we have Ritesh More, who is a software developer and a software consultant. So today's we are going to talk about computer-related inventions and the roadblocks securing patents in this domain. So we will start by just giving a short overview about what are computer-related inventions. In general, the software inventions are precious to us because every now and then we keep on devising a new software, a new computer program, and just looking at the technology which is prevailing right now, it is very hard to live without a software program. We are devising ways, businesses around the software. So it's very important for us to protect the software to curb the market competition. So I would just like to ask Josh, as a technologist, what kind of roadblocks and what kind of threats he feels when he devises a new technology and when he devises a new software.
Yes, hi everybody. Nice to meet everybody. My name is Josh, and I'm in New York. We're developing a software for food ordering for restaurants. It's you go, you see restaurants menu, and you can order from them. The roadblocks that I see in technology right now are really gone. In the past, we had the roadblocks was the speed for internet and maybe even the processors, but as technology has improved nowadays, with 5G coming along, internet speed and the processing speed have dramatically improved, and it allows us to do anything, process anything, even from cloud computing. It lets us pretty much do anything. You know, sky is the limit. Anything you can imagine, you can build nowadays with the software codes and the processing speed that we have. Honestly, your imagination is your only limit.
Yes, that's right. So I would like to know the same from Ritesh as well. Ritesh, while you devise or work on a software project, are there any apprehensions in your mind that the software is going to be leaked out and how you're going to protect your rights?
Well, the first important thing when we are building a software, the main thing is like understanding the requirement of the client, and and the proper front end part, like how the client is going to use the front page, because on that basis we are going to also design the back end part, this programming and the coding, and eventually
you must be using graphic images, you must be using copyrighted material, you know, just for devising the graphical user interface. So when you devise complete software, do you feel that there is a need for you know, the protection of the software itself?
Yes, perfection of the software, and also the good point you mentioned about the copyrights, because if if you are using some pirated image or anything, the Google will automatically block your website.
Yes, that's true.
Yeah.
So, have you have you ever thought that how there should be a protocol, there should be a clearly marked protocol, how to file copyrights, how to file design patents, and, you know, and as far as protecting the overall look of the graphical user interface. So do you file the patents very actively to protect your software inventions? This is to both of you, Josh and Ritesh.
Yeah, if our the graphic designer is more legit and its own, if he or she can create on the basis of their own imagination, then I don't think there will be any roadblocks or copyright issues will be there.
Yes,
so
I would
somehow
like to know it from Josh as well. Josh, can you throw some light on the kind of threats that you feel while you design or, you know, like work on a software invention?
In terms of design, what kind of threats in terms of design?
in terms of like when you devise a technology platform, for example, say when we were working on perk jobs, what kind of threats and what kind of roadblocks do you feel, as a software technologist that can potentially come your way?
Well, technology changes really fast,
Yes.
especially with software. I've had to design stuff over and over just because a few months later, it already has changed.
Yes,
Uh,
that's right.
that's really the major roadblock that I see when it comes to designs. It's just that it changes so dramatically. You just have to over and over right away.
Yes. And
And
how do you protect the overall idea apart from design patterns? What do you file the utility patterns also to protect your software inventions? And how far is the success rate of all those applications go? It just goes.
That's really, I think, the difficult part is to find the core of the design and try to patent that.
Yes.
Because it changes so fast that if you can find the core and patent that, maybe you can surf along with the changes. But that's where you really need to sit down and think.
Yes, and there are restrictions, Ritesh, there are restrictions in filing software patents in many countries. For example, in India, only the inventions which qualify the technicality threshold are eligible to, qualify as a software patent. And then there are less patents, as far as the software domain goes, filed in India. And US is a different case because yes, there are software and business patents filed in the United States, and so far they have been granted also. But at the same time, there is a very stringent criteria for a software application to qualify and mature into a patent application. The first criteria that generally is a roadblock is the technicality threshold. Your software invention has to be technical enough to qualify the patenting criteria. And what is technicality? In general is just it's very confusing because the law doesn't define technicality in depth. So sometimes a software invention basically uses a business method, or a business method uses a software application to run. And if you apply those inventions as patent applications, you have to be very careful whether you qualify the technicality criteria, whether your software solves a business problem or it targets a technical problem. So latter is more important than the former one. Yeah, Ritesh, you want to say something in between?
yeah, I would like to add one more point. There is an argument like the similarity between the output of two, say, for example, two websites, but they might have used the different pattern,
Yes, of
the
course,
different
the
method
process.
or different languages. Yeah,
Yes, yes,
yeah,
that's true.
and some. So we can't say directly that okay, it's a copy or something like that. So there is still an argument like how can we say that this is the exact copy, because even though the outcome is similar,
The
but the
product is
method and
similar.
the
Yes, the
yeah
process and the
and
algorithm can vary. This is what you. I think
yes.
Josh can throw some light on this because Josh has been very actively involved in patenting a couple of algorithms. Josh, can you tell us about your journey? Trying to protect and safeguard the algorithms based on different inventions that you like design.
You just gotta be really smart. That's the way I'm looking at it. Like, if I have an idea, I go over it with many, many different people, and then go over it again and again and again and again. Just because whatever you patent, it has to be right. It's something that you can't change again. And it's got to be very well thought out. It's got to have a lot of foresight. You got to know where the technology is going, where the market is going, where everything is going, so that whatever you patent, it's going to be good for 20 years.
Good
I
for
mean, I know
20
that
years.
sounds ridiculous, but especially with technology. But I feel like to patent something, you gotta be that much ahead.
Yeah.
That is so that when you finally do get your patent, and we know how difficult that is, it's worthwhile. It's worth something, and it's something that even like after 20 years, they're still wanting to use it the way you made it. So that's really it. You know, you just gotta have a lot of foresight.
And Josh, what do you think about copyrights in general? Because if you attain a copyright over a software, you straight away attain it for 60 odd years. But copyright is a weaker protection as compared to full-fledged utility patent. So have you ever thought of filing copyrights, or do they actually fall
You
in the
know,
line of your thinking?
it's especially nowadays, like, you know, with copyrights, I think they're pretty brilliant. They're even they, you know, if it's well thought out, they, I think, offer just as much protection as patents.
Yes.
But you just have to be so ahead of the game. If you copyright something, and it saves time and it just saves a lot of work for the users, then it's very valuable. But again, like, it changes so fast and so dramatically that if you're gonna copyright it, and it's just gotta be so well thought out so that when it does change with technology, yours is still in play.
Yes, yes, and similar is the case of patents, because we land up filing the divisional, additional, and CIB applications just to upgrade ourselves, and just keep ourselves up in the game. Ritesh, one question to you: when you design softwares, do you formally register the copyrights at the respective national office, or you just go on by default copyright method? Have you tried to copyright your software, or your company tries to copyright the software specifically?
Well, I don't know about the government copyrights and all, but in general, the company do uh, what we say, the contract between the developer and the owner. Like, if
Yeah.
you develop any code or a piece of code or a program, anything, you
Yes.
should not sell this piece of code to
That's a
the
contract.
other company.
Yeah, that's a
Yeah, yeah.
contract, but not actively filing copyright
No,
applications. Yes, so it's
no, no.
Josh. There is one thing, because I have seen a lot of inventors, across the globe. Still now, people are very, like, they are not. I don't know whether the lack of knowledge, or whether they don't want to file it. Still, in today's time, people try to refrain from actually filing valid registration applications. For example, filing a copyright application, filing a design application. And if we see the inventors from the US, they are particularly interested, before even launching their idea, to protect, their intellectual property. So, how do you, like, how do you basically see this paradigm shift in the behaviors of different, like, inventors across the globe?
I've learned in the past few years that the patents and copyrights are so difficult, very technical. You really need to know what you're doing, and even then, there's so much room for interpretation. So I feel like that's one of the reasons why a lot of people stay away from patents, or don't file it. It's because really a lack of knowledge. You just need to have a group of very experienced and knowledgeable people knowing what they're doing,
Yes.
to be able to get from start to finish. It's a very technical, and I would say, difficult process.
Yes.
Very long.
Long process. Yes. Yes, that's
And
true. I think Josh knows better, because Josh, I think, has been with us for, like, quite a long time.
Few
But
years, a few years.
I would like to add here, Josh. Apart from the computer-related inventions, I would like to know: have you even tried to trademark the, like, brand name for the softwares? Is that an agenda on your list? Do you in future?
Anything. This is such a big, complex world that anything I can get my hands on, I'll do.
Yeah.
Just, just so I can learn the process, and just get some experience. anything really. You know, all of this is power. Just the experience going through it, even if you fail, is just the knowledge that you gain from it is just so powerful. I feel like this is the upper hand, is the
Yes.
knowledge.
Yes. I would like to know, as far as the United States go, what is like the general mood of the people? If they come up with a new invention, do they still approach an attorney for patenting those inventions, or are they active enough in the field of IPR in general?
I feel like it's so difficult, and it's so long. It's such a expensive, especially in the United States. It's very expensive. Very long process, and then you have to divulge everything. I think people are staying away from filing patents and copyrights just because they don't know how to do it. It's expensive. It's a long process, and then they have to say everything.
Yes.
Uh, and I feel like that is sort of like scaring away people. But I've learned with Manisha in the past few years that, you know, you can be smart about it too. You don't have to divulge everything, and you can be very general, very broad, and also get protection, not from suing people or going after people who violate your patents or copyrights, but if they come after you
Yes.
and say,
You
you know,
have a
you're
defensive portfolio with you. Yes.
Defensive, yeah, yeah.
Yes.
defensive. So that's really why I, you know, want to do things. Is because, you know, get it on record that, you know, you have a patent, you have a copyright, and you know, you were there first.
Yes, so making and building up a portfolio is important. Ritesh, what is your view on building up a patent portfolio, or in general an IPR portfolio, you know, consisting of software patents, design patents, trademarks, just to protect your intellectual property? How far you know, your firm is actually doing that? Are you active in securing the IPR for most of the softwares that you design?
No, actually, we don't do any of this. But yeah, but to protect this, you know, we follow the technical part. It's like we don't provide the whole set of code. Instead of that, we provide the DLL files
Oh yes, yes,
where,
that's
yeah,
pretty technical actually. You know,
yeah,
and you're talking about the European zone, you know, where you're practicing right now.
yeah, yeah,
Okay,
exactly.
this is the mood of. But we have seen the EPO, which is a European Patent Office, has been rejecting a lot of software-based applications. Their technicality criteria for software and business patents is something which you cannot overcome. And if you don't qualify the technicality, they're straight away going to reject your application. So I was more interested from the European perspective also to know whether the inventors, you know, like you, are actually protecting their inventions in Europe. So this was the case. And if there are still apprehensions over filing the software patents or in
Yeah,
general IPR, I mean, that really needs to be worked upon. What do you think about that?
yes. Yes, yes, exactly. Because most of the people don't know, especially we technical and engineers, about the IPR and registration
Yes,
and the,
yes,
you know, yeah, all this part.
yes.
So yeah, this is something I think it's very necessary, and just to protect their own right, what they have created, and giving more value to their work.
Yes, and in general, I think most of the startups in the European region are more focused on the contractual and the agreement-based, you know,
Yes,
like setups of protecting their IPR rather than filing it, you know, actively.
yes, yes,
Okay, so
exactly.
that should be changed. Josh, your thoughts on the same thing? What is the mood of the startups in the United States? Are they active enough?
They're active enough, you know, because that's where the money is right now.
Yes.
This is it. It's in technology right now. Sometimes I feel like it's the only thing driving our economy is technology. We're- Everything else is sort of lagging behind. I can see it. I can see it in our markets. It's the only thing that we're focused on, and I don't see an end in sight. It just keeps getting bigger and bigger and bigger.
Yes,
So
and I think software is the future. It's the present, it's the future, and I think allowing somebody to have complete control over their, IPR on a particular software that they design is very important. Especially when we are landing up in an era where we have started using cryptocurrencies, we are into fin technology, that is fintech. Then it's necessary to protect these like domains, and the patent offices of respective jurisdictions and respective countries should inculcate more and more better practices of saving and securing patents or designs and IPR rights over software. This has been the this is basically the agenda of this entire talk, to basically work out how, first of all, to decide whether the software patents are necessary, and if yes, they are necessary, then the ways and the roadblocks, how we can overcome those roadblocks, and how we can secure our IP over the software portfolio. So in general, we've discussed most of the points. Josh, any of the ending notes by you that you would like to share with the other people?
Yeah, it's worth with technology playing such a big role in our world. It's definitely something to consider, to go after and try to get patents and copyrights, because if it does work and you do get granted, it's just so valuable because the industry is so valuable. So when it comes to technology, anything you can patent or copyright, I'm all for it. Even if it means that it's very unlikely to get granted, I'll just do it anyways.
Yes, that's strengthening your portfolio. I think after all, it's very imperative in the competitive world today to have a defensive portfolio of intellectual property rights with you, and so is the case. Ritesh, your ending note on the software patents, and what do you feel? And in future, would you file patents for the same?
I think it's very important right now, because even though whatever you create, maybe at initial stage it may be it's small and at the beginners level, but later on, who knows, you click any idea and you want to grow further, so the others can't able to you shouldn't get what do you say, uh,
Stop yourself, securing the
yeah,
IP of
obstacles.
the software.
Yes,
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 and overcome the obstacle.
exactly.
Yes, yes.
Yeah.
So I would thank you, Josh. Thank you, Ritesh, for attending this session. This
Yeah.
has been a chit chat on the software patents, CRI, computer-related inventions, and roadblocks. And if you have any questions, we would be glad to assist you with your queries. You can log on to our website, www.patfrigate.com, and we'll be glad to help. Thank you so much, all the panelists, for joining us.
Thank you.
Thank you.
Thank
Thank
you.
you.
Thank you, Ritesh.
Thank you. Thank you, Josh.
Bye bye.
Bye bye.
Bye.